Recognizes the gentleman from Florida's 12th District for 5 minutes for questions.
Thank you very much, Mr. Chairman. I appreciate it very much. I want to thank the panel as well. Whenever we talk about Section 230 or online privacy protections, I'm particularly focused on how we best protect our nation's children. Children and teens spend the most of the time on the internet, and there are some of the most manipulated, unfortunately. In a hearing a few years ago, I had a discussion with witnesses on how Section 230 interacts with child exploitation online. We explored how special immunities are granted to online platforms that don't exist for brick or mortar stores when it comes to a business knowingly exploiting our children and facilitating child pornography. I want to expand on this very serious issue. A 2019 New York Times podcast reported that the FBI has to prioritize sexual exploitation cases of infants and toddlers because it cannot effectively respond to all reports. This leaves older children less protected and therefore more likely to be repeatedly abused, unfortunately. Ms. Leary, if the FBI cannot pursue a case against a platform due to lack of resources under current law, can a state attorney general file criminal charges under state law, or would Section 230 block that case as well?
Thank you, Congressman. The way that Section 230 has been interpreted, the answer would be no. There's a provision after these 26 words we've talked about, which says no state law inconsistent with this should be followed. It's not phrased quite like that. And courts have interpreted that to say states can't enforce their own criminal laws. And you're quite right. Child exploitation in this country, in part due to these platforms, is exploding, and we need to have multiple pressure points, state and local, federal and not, civil litigation, criminal litigation, and by telling states they cannot enforce their own criminal laws or their own regulations has a very challenging effect on these online forms of exploitation.
So again, just like with lawsuits brought by victims of child sexual exploitation online, there is no reason why we should be giving special immunity, in my opinion, on online platforms where they facilitate child pornography. I agree with you. It is so shameful that our own laws prevent state AGs, it's unbelievable, from prosecuting child pornography facilitators when the FBI cannot handle the cases themselves. Let's close the loophole, folks. Let's close the loophole and get more cops on the street to stop these predators. So my second question is, Dr. Franks, Section 230C2 states that a provider is protected under the good faith standard for material that is obscene or otherwise objectionable. Does this mean that the provider can shield itself from liability simply because at least one of its users has flagged content as personally objectionable? And if so, would that provider protection still exist if the user flagged the post in bad faith, perhaps because they didn't agree with the position of the original poster?
So the protections of C2 would not be dependent on users at all. So it would not need to rest on whether or not a user has said this is objectionable. The C2 provision says that the provider themselves finds that this is objectionable or any of the other obscene, lewd, lascivious, et cetera, any of those kinds of characteristics, it is allowed to restrict access to that content and cannot face civil liability for that basis. And I think it's also important to note that even though that's a procedural protection that is important in C2, this is really building on a foundation that actually reinforces something about First Amendment law as well. Namely that these social media companies, while they might not seem like it, they are private actors in the sense that they are not government agencies, they are not government agents. And so the First Amendment operates for them both in terms of what they can say and also what they don't have to say. And so the First Amendment already gives them the power to take things down, to choose not to post speech, to choose to restrict access, They can do all of those things based on their powers under the First Amendment, and then C2 gives them extra procedural protection.
Okay, I guess I've got to yield back. Thank you very much, Mr. Chairman. Appreciate
Well,
it.
thank you very much, gentlemen.